Imagine taking your car to a mechanic, right?
Right.
You pay this massive premium up front, and then later you find out they aren't even a mechanic.
Right. They just rented a uniform.
Exactly. They rented the shirt. Worse, they haven't even popped the hood of your car, but they've already drained your wallet. That is exactly what is happening to thousands of really vulnerable people right now in the $23 billion debt relief industry.
It's massive.
It is. So welcome to this personalized deep dive. We are pulling all of our insights today from this really eye-opening investigative report. It's called The Attorney Model: Exposing the Debt Relief Loophole. And our mission today is to just cut through all the confusion and expose this highly predatory tactic that is legally draining people's pockets.
Okay, let's unpack this because the scale of it is wild. It really is wild. And, well, what's fascinating here, it's the dark irony of it all. Because this is a space filled with a lot of desperation, you know. These services market themselves as a lifeline. They tell you they can fast-track getting you out of the red. But this specific loophole we're looking at, it legally allows these companies to take your money while actively destroying your credit score at the exact same time.
Which is just, it's so backward. And look, even if you aren't currently juggling debts yourself, you really need to understand this. The global debt settlement market, they're projecting it to hit $7.2 billion by 2032.
Yeah, that's a massive ecosystem.
It's huge. So understanding how these traps operate on a mechanical level, it's essential armor. It protects you or, anyone you care about who might suddenly face a layoff or a medical emergency.
Yeah.
Because life comes at you fast.
It does. And to really grasp how the trap works, I mean, mechanically, we have to look at the human element first.
Right.
Because billions of dollars, that sounds abstract. But the actual mechanism of this loophole, it preys on very human psychology.
So let's look at a story from the source material that perfectly illustrates this. There's this woman, Carol Din. She's 31, a former project manager living down in Atlanta. She was working 2 jobs, and she unexpectedly lost one of them.
Which is a nightmare scenario for anyone.
Total nightmare. Her income gets slashed, the bills pile up, and suddenly she's staring at $27,000 in credit card debt.
And she was really trying to be responsible about it. But the psychological weight of that kind of debt is immense.
Oh, yeah.
She just felt completely overwhelmed. The minimum payments were eating her alive. So she was desperately looking for a way to streamline everything, like maybe find a lump sum option to just stop the bleeding,
Right. So in November 2023, feeling totally stuck, she enrolls with a company called the Clear Creek Legal Debt Resolution Program. And they sent her this incredibly reassuring welcome email telling her, she made a brilliant choice. They're going to negotiate and resolve her debts for a fraction of what she owes.
It sounds like exactly what she wanted to hear.
Exactly. But then they give her the first set of instructions. They tell her to completely stop paying her creditors. Like 0. And instead, she's supposed to redirect her monthly payments into a special trust account that Clear Creek controls, supposedly to build up a settlement fund.
Yeah, that's the pivot point right there.
Wait, they told her to deliberately stop paying her bills? I mean, isn't that just financial suicide?
Well, on the surface, yes. It sounds disastrous. But stopping payments is actually a genuine, recognized tactic in debt settlement.
Really?
Yeah, and it's based entirely on leverage. Think about it. If you are consistently making your minimum payments, a credit card company has 0 incentive to negotiate with you.
I guess that makes sense.
Right. Why would a bank take a loss on your balance when you're still actively paying them every single month? But the moment you stop paying, the creditor has to face the reality that they might end up with nothing, especially if you declare bankruptcy.
Ah, so you're forcing their hand.
Exactly. That fear is literally the only thing that forces a massive banks to the negotiating table to accept a reduced lump sum.
Okay, I see the logic. But the collateral damage there has to be massive. I mean, the moment you stop paying, you're going to get hit with penalty interest rates, late fees, and your credit score is going to absolutely plummet.
Oh, it did. Her score completely tanked.
Yeah.
It dropped from the 700s all the way down to the 400s.
Ouch.
Yeah. And this brings us to why the whole legal illusion is so incredibly damaging here. Because a legitimate attorney, they act as a fiduciary.
Meaning they have to protect you.
Right. They are legally and ethically bound to act in your best financial interest. So a real lawyer would have reviewed Carol's file and told her, hey, because you aren't actually delinquent on your accounts yet, you lack the leverage needed to force a settlement.
Because she was still current on her payments when she called them.
Exactly. But Clear Creek didn't tell her any of that. They just rolled out the red carpet and took her money anyway.
Which brings us to the core of this whole deep dive. The actual attorney model loophole itself. Because the source material outlines some pretty strict federal laws, like the telemarketing sales rule,
Yeah,
right?
the TSR.
And the Consumer Financial Protection Act. And these laws explicitly ban debt settlement companies from charging upfront fees. They can only charge you, and it's usually around like 15 to 25% of your enrolled debt after they actually deliver a result.
Which is how it should be. Those federal bans exist precisely to stop companies from taking money from people who are already broke without guaranteeing a service.
Right.
However, and here is the loophole, licensed attorneys operate under an entirely different set of rules. It is standard practice in the legal profession to collect advance fees.
Like a retainer.
Exactly, known as retainers, before any work is actually done.
Mhm.
So these predatory debt settlement firms realize that if they simply masquerade as a law firm, they bypass the federal consumer protection laws entirely. They can grab your cash on day one.
So they just slap the word legal in their name, like Clear Creek, Legal Debt Resolution Program, and suddenly they're immune to federal fee bans.
Essentially, yes. And for Carol, she spent 3 months trying to get straight answers about when her debt would actually be paid off. When she realized she was just being given the runaround, she tried to quit. But she had already paid them nearly $1,500.
Oh, wow.
And Clear Creek kept almost $500 of it. They claimed it was for, quote, account setup fees. So she lost $500, torpedoed her own credit score, and her debt hadn't gone down a single cent.
That is just brutal. So what does this all mean mechanically? I'm trying to wrap my head around how they actually get away with this illusion at such a massive scale. It's basically like a restaurant renting a Michelin star chef's name for their menu, but the food is actually being cooked by a teenager in a microwave.
That is a perfect analogy.
Right, they just rent the title.
Right. Yeah, the industry literally calls it fronting the license. It is a calculated rental agreement. We have quotes here from Martin Lynch, he's the president of the Financial Counseling Association of America, and Andrew Pizor, a senior attorney at the National Consumer Law Center.
And they break this down.
Yeah, they both outline this in the report. These corporations essentially rent a law license. The attorneys just lend their name to a letterhead. They are absolutely not sitting in an office reviewing your financial hardship case.
And Carol confirmed that in her story, right? She noted that whenever she called Clear Creek, she was talking to outsourced customer service agents, not lawyers. Pizar even mentions that some of these massive operations outsource their call centers to entirely different countries.
Exactly. The only time Carol encountered a process that felt remotely legal was when Clear Creek dispatched a notary to her house.
A notary? Why?
They had her sign power of attorney paperwork, which allows the company to communicate with her creditors on her behalf. And, the term power of attorney sounds incredibly intimidating and official.
Yeah, it sounds like you're in a courtroom.
Right, but you do not actually need a lawyer to execute it. It is just routine paperwork, wrapped in the illusion of bespoke legal counsel.
So it is pure theater. And the crazy thing is, it's not even a new trick. The source material traces this all the way back to 2007. There was this company called Morgan Drexen.
Oh, yeah.
And they eventually got sued by the Consumer Financial Protection Bureau, the CFPB, and had to pay $132 million in restitution. You would think a 9-figure penalty like that would just kill the model entirely. But it looks like the industry just used it as a learning experience to build a better mousetrap.
If we connect this to the bigger picture, they absolutely refined the scheme. Fast forward to January 2024, the CFPB and 7 state attorneys general launched a massive civil complaint against an operation called Strategic Financial Solutions, or SFS.
Right, SFS.
Regulators alleged SFS lured vulnerable borrowers in and charged them more than $100 million in illegal upfront fees, often without ever settling a single debt.
$100 million in illegal fees. The scale of that lawsuit is just staggering. And the CFPB listed 29 corporate defendants and 17 quote-unquote facade law firms.
Just shell companies, basically.
Yeah. And here's the twist. When the CFPB amended their complaint, Clear Creek, the exact same company Carol Den used, was named as one of those facade firms.
Which just reveals how interconnected the entire web is. But SFS fought back in court, and they used a very specific legal maneuver.
What did they do?
They argued their advance fees were perfectly legal because the telemarketing sales rule has an exemption for, quote, face-to-face sales presentations.
Wait, but they operate remotely. They've outsourced call centers in other countries. How on earth do you claim a face-to-face exemption when you're talking to someone on a phone?
That is where the notary comes in.
No way.
Yes. They argued that because they sent a physical human being, the notary, to the consumer's living room to sign the power of attorney, it constituted a face-to-face interaction under the federal law.
That is so incredibly calculated. The notary isn't just there for the theatrical illusion of a law firm. They are literally being used as a legal shield to exploit a loophole in federal telemarketing laws.
Exactly. Now, the courts ultimately rejected that argument. They pointed out that the actual sales pitch and the financial agreement happened remotely, so a notary showing up weeks later doesn't trigger the exemption.
Good.
And SFS had its assets placed under a court-appointed receiver. But the fight isn't over. In November 2025, SFS filed a motion to dismiss the case entirely. And if they win that motion, regulators lose years of progress.
Wait, if the CFPB knows exactly how this loophole works and they are actively suing companies like SFS for hundreds of millions of dollars, why hasn't this industry been shut down permanently? How is it still growing to $7.2 billion?
Well, the sheer volume of the problem is overwhelming. And the regulatory bodies are currently facing an unprecedented structural bottleneck.
What kind of bottleneck?
To put the volume in perspective first, consumers filed over 34,000 complaints with the FTC in 2024 alone, just regarding shoddy debt and mortgage relief.
Jeez.
And those complaints represent over $82 million in reported losses.
And while those tens of thousands of complaints are just piling up on desks, the agencies themselves are going through massive political and legal shifts.
Right.
And I want to be super clear with the listener here. We are not taking any political sides. We are just neutrally outlining the facts from the source material about how these shifts affect oversight.
Exactly. We're just looking at the regulatory reality.
Right. So the source notes a few major events. In July 2025, the One Big Beautiful Bill Act was signed into law, which significantly hobbled the borrowing power of the CFPB. And at the exact same time, there were announcements to add $18 million specifically from the FTC's Bureau of Consumer Protection.
And we also have to look at the pushback, like the NTEU v. Vought lawsuit.
Right, the union lawsuit.
Yeah, the CFPB Employees Union is currently suing the executive branch. They're challenging the legal authority to effectively shut down or dismantle a congressionally established agency without passing new legislation.
So when a massive regulatory agency gets tied up in an existential lawsuit over its own survival and simultaneously loses $18 million in funding, they simply lose the manpower.
They absolutely do.
You can't dedicate teams of investigators to chase down 17 different shell companies hiding behind a single rented law license when you are fighting for your own budget.
That legal tug of war creates a massive gray area. When federal agencies are paralyzed, it just creates breathing room for predatory companies to operate and invent new workarounds.
So if federal oversight is tied up in lawsuits and budget cuts, who is watching the store? Does the burden just fall to the individual states?
Well, state attorneys general do step in,
Yeah.
but it's incredibly difficult. And they are severely handicapped by the quote-unquote attorney aspect of the attorney model.
Because they're technically law firms.
Exactly. Because these companies hide behind law licenses, state regulators have a very high bar to clear. Andrew Pizor points out that to trigger a real investigation into a law firm at the state level, you generally need proof of outright malpractice or theft, not just bad service.
Meaning, if a company charges you $1,500 and just provides really terrible, overpriced service, that's not enough for the state bar to kick the door down.
Right. Bad service is just treated as a consumer dispute. State bars are looking for crimes, like an attorney literally stealing money directly out of a client's trust account.
Wow.
And adding to the absurdity of it all, the telemarketing sales rule relies heavily on debt settlement companies self-reporting their own practices.
Wait, really? That is wild. We are basically asking the people exploiting the loophole to grade their own homework.
Yep. Martin Lynch makes the exact point that the system is broken without regulators pulling random cases to audit the actual outcomes. Relying on self-reporting from bad actors leaves a massive, massive blind spot.
So if the federal regulators are legally gridlocked and the state regulators are hamstrung by the rules of the state bar, and the whole system relies on self-reporting, I mean, the defense against this $23 billion machine falls entirely on you, the consumer.
It really does, which is why we have to pivot to actionable defense here. And we should acknowledge that legitimate debt settlement does actually exist.
It's not all bad apples.
No, not at all.
Mhm.
In 2022, reputable companies resolved more than $2.8 billion in unsecured consumer debt, and they helped over 1.2 million accounts.
Okay, so the good actors are out there, but we need to know how to spot the bad ones. And here's where it gets really interesting. The source material lists some very specific red flags. And my absolute favorite, just because of how blatant it is what they call false authority claims.
Oh, those are the worst.
If you hear a late night commercial or you get an email claiming that, the president recently signed a new bill saying you don't have to pay your credit cards back run, it is entirely fabricated. They just prey on people looking for a magic wand.
Yeah, beyond the blatant fabrications like that, the experts we reviewed outlined several critical warnings. The first, as we've thoroughly established today, is upfront fees.
Right.
No legitimate debt settlement company will ask you for a dime before your debt is actually settled.
And I'm also guessing those ads promising to, like, cut your debt in half guaranteed are lying too. Because you can't actually guarantee a massive bank will agree to a deal, right?
Any company promising a guaranteed outcome is lying to you. Full stop. The bank holds the cards. You also need to watch out for unclear timelines and companies that completely gloss over the severe risks.
Like what?
Like the fact that forgiven debt can actually be treated as taxable income by the IRS, or the guaranteed damage to your credit score. If they aren't warning you about that, they aren't legitimate.
What about the way they actually contact you?
Legitimate companies wait for you to seek them out. If a debt settlement operation is cold calling you, emailing you unsolicited, or using high-pressure sales tactics to force you into signing a contract right that second, hang up the phone.
Good to know.
And finally, be incredibly wary of any company offering to settle secured debts, like a house or a car.
Because secured debts are tied to a physical asset, right? You can't settle a car loan or a mortgage by just stopping your payments, because the bank will just send a repo truck or foreclose on your house. Debt settlement is exclusively for unsecured debt, like credit cards or medical bills.
Exactly. Understanding those mechanics is the difference between finding a real resolution and falling into a total financial disaster. Let's actually bring this back to Carol Den, because she did find a way out.
She did. After she finally walked away from Clear Creek, bruised and missing $500, her bank recommended she look into a nonprofit credit counseling agency. So she connected with Money Management International, or MMI.
Right.
And instead of a risky debt settlement program, they put her on a debt management plan, a DMP.
And the mechanics of a debt management plan are fundamentally different. With a DMP, you do not stop paying your creditors. You continue to pay them, but you make one consolidated monthly payment directly through the credit counseling agency.
So your credit score doesn't get deliberately nuked.
Exactly.
But wait, why would the bank agree to lower your interest rates if you were still paying them? I thought you said earlier they only negotiate when you stop paying.
That is the brilliance of the nonprofit model. Credit counseling agencies like MMI have pre-established institutional agreements with major banks.
Oh, so they already have a relationship.
Yes, the banks are willing to lower your interest rates and waive late fees because the agency ensures the bank will get their principal balance back over time rather than losing it entirely to a bankruptcy court. A DMP ensures that your monthly payment actually attacks the principal rather than you just treading water on high interest forever.
Okay, now in the interest of total impartiality and transparency, DMPs do charge upfront fees, which sounds exactly like the red flag we just warned people about.
They do have fees, yes, but the context and the scale are entirely different. Because these are nonprofits, the fees for a debt management plan are strictly regulated at the state level.
So they can't just make up a number.
Right. They are not arbitrary cash grabs. MMI, for example, charges an average setup fee of just $38 and an average monthly processing fee of $27.
$38 compared to the nearly $1,500 Carol handed over to Clear Creek in just 3 months? That's a massive difference. Now, the trade-off with the DMP is that it requires a lot of time. It's a structured marathon, usually measured in years.
It does require patience, definitely. But the results are mathematical and tangible. When Carol signed up with MMI in 2023, the initial projection was that she would be debt-free by August 2028.
Okay.
But because her principal is actually being paid down efficiently now, she has shrunk that timeline. She's now looking at finishing by January 2028, possibly even mid-2027.
That's amazing.
And most importantly, her credit score is actively recovering while she does it.
She actually said it perfectly in the report. She said, "It feels good to work with a company that's actually helping me instead of hurting me and to see real progress."
Yeah, that's the ideal outcome.
It really is. We've covered a lot of ground today. We've peered inside a $23 billion industry. We exposed how the attorney model allows predatory companies to just rent law licenses and bypass federal laws. We've looked at the regulatory gridlock at the federal and state levels that, allow these shell companies to thrive. And we've walked through the actionable red flags and legitimate alternatives like DMPs that actually work.
It's a lot to take in. And as we wrap up, this research actually raises a broader, almost philosophical question about the macroeconomics of this entire industry.
Oh.
Because the source notes that the debt settlement industry historically expands and rebounds during periods of high financial stress. Yet it's projected to hit $7.2 billion soon, even when we aren't in a recession.
So basically thrives when people are hurting.
Exactly. So here is a final provocative thought to ponder long after this deep dive ends. If a massive, multi-billion-dollar industry fundamentally relies on consumer financial fragility to grow, does our modern credit-based economy actually need a certain percentage of people to fail just to sustain the secondary market?
Wow.
Right. At what point does the business of, quote-unquote, helping people become far more lucrative than the original debts themselves?
That is a really heavy but vital question to think about. Look, at the end of the day, you don't want to find yourself handing over your hard-earned cash to a mechanic who has absolutely no intention of ever fixing your car.
Definitely not.
But now you are armed with the insights to spot the illusion before they even ask to pop the hood. Thank you for joining us on this custom deep dive. Stay curious, stay protected, and we will catch you on the next one.